All right, so this is the next lesson in the course, Securing the Blessings of Liberty, an examination of the United States Constitution. In this class, we're going to look at the rest of the text of the original Constitution, as well as the first 10 amendments, which are called the Bill of Rights. So we'll finish up the judicial branch as well as the remaining articles, as well as look at some of the history that went into the Bill of Rights, the conflicts between the Federalists and the Anti-Federalists, and some of the arguments for and against the Constitution. And we'll see how many of the provisions, especially the Bill of Rights, are being greatly violated today by government on all levels. Last time we didn't get quite as far as what we should have, and so we're putting a little bit extra into this first session today. And in this first session, we'll hope to get through Articles 3 through 7 of the Constitution. So that will be all of the text of the original Constitution. And in the second session, then we'll be looking at the Bill of Rights. And so in our diagram that we've been adding to as we go along through the Constitution, this is where we left off last time. Article 1 talked about the legislature and how it's split into a House and a Senate, two houses. Originally, one of those houses was elected by the people, and the other house was elected by the state legislatures. The Senate originally was elected by the state legislatures. That was changed with the 17th Amendment. And last time as well, we talked about the executive branch. And the executive branch really is embodied in one person. Certainly there's many different officers and positions within the executive branch, but you have the president. And the president is not elected directly. The president is elected through an electoral college system. And again, originally, most of the states selected their electors by their state legislatures. Now today, many of the electors, in fact almost all electors, are chosen through election by the people. And that's not something that required a change in the Constitution. The Constitution specifies that the states can decide how to select their electors. Now today we come then to the judicial branch. And the judicial branch of the federal government there are many federal courts, but there is the Supreme Court that is kind of the final authority with regard to judicial matters. And the Supreme Court, rather than being elected, the Supreme Court justices are appointed by the president, by the executive branch, and they have to be confirmed by the legislature. And so the legislature and the president have to work together in that regard to put people on the Supreme Court. And the judicial branch, rather, is a necessary branch of the federal government. It can also be a very dangerous branch of the federal government. Remember that under the Articles of Confederation, there was no Supreme Court. There was no federal court system at all, only the state courts. And so in the Constitution, they were seeking to fix that, to provide a court that would be the highest court in the land. And the Supreme Court has, in a few cases, they have what's called original jurisdiction, which means that they would be the first court to hear a case. And those are cases that affect ambassadors, public ministers, and consuls, and cases in which a state is a party. The Supreme Court has original jurisdiction in those cases, and the Supreme Court has appellate jurisdiction in all other cases. So appeals, somebody can continue to appeal their case up through the court system, up to the Supreme Court, although the court's appellate jurisdiction is subject to exceptions and regulations of Congress. And so the Supreme Court really is not a completely independent branch. especially with regard to appellate jurisdiction. Now, with their original jurisdiction, Congress cannot affect that, but with appellate jurisdiction, Congress can put limitations on the jurisdiction of the Supreme Court. And that's an important power that the legislature has. Now, it's very rare that they do that, but often you hear about some of these bad court decisions. One certainly that comes to mind is the Roe versus Wade decision, a decision that really did away with the state's ability to decide how to deal with the issue of abortion, and instead it made the state laws unenforceable. Many state laws still exist with regard to abortion. Here in Wisconsin, according to our state law, abortion is greatly restricted, but those laws are not enforceable because of a court decision. And often the President and Congress, they like to pass the buck on a lot of these issues to the judicial branch and say that they have no power to do anything. The judicial branch has determined what the Constitution means and how it's to be applied. The fact is that Congress can limit the jurisdiction of the Supreme Court. In fact, the Congress, if they wanted to, they could take the issue of abortion or gay marriage or a lot of these other issues that have been important issues in the courts, and they could remove them from the Supreme Court's appellate jurisdiction if they desired. And what that would do is it would allow the states then to determine what they wanted to do with those things, and those cases could not go any farther than the state courts. The Anti-Federalists had some criticisms of the Supreme Court as set up by the Constitution, and one had to do with the way that the Supreme Court is defined in the Constitution violates some principles of common law. In the Federal Farmer number 15, the Federal Farmer, those papers would have been part of what are sometimes called the Anti-Federalist papers, the oppositions to the Constitution. And Federal Farmer number 15 said, "By the common law, there is no appeal from the verdict of the jury as to facts to any judges whatever. The jurisdiction of the jury is complete and final in this, and only errors in laws are carried up to the Supreme Court. If the jurisdiction of the jury be not final as to facts, it is of little or no importance." Now, if you look in your Constitution and look at Article 3 about the Supreme Court, it'll say that they have jurisdiction not just over law, but over facts. And the difference is, in a court, in a jury trial, you have the judge. The judge is there to make sure the law is followed. The jury is there to determine the fact of guilt or absence of guilt. Now, what the Constitution says is that the Supreme Court has the power, has appellate jurisdiction, not just as to the law, not to just make sure the law was followed, but as to the fact as well. And so under the original Constitution, the Supreme Court could have overturned jury verdicts. Now, when we get to the Bill of Rights, we'll see that there's a provision that the courts cannot overturn the decision of a jury as to fact. Okay? But that was a valid criticism by the Anti-Federalists. The judicial branch is a very dangerous branch of the government. Here's what Thomas Jefferson had to say. Jefferson, by the way, originally, now understand, Jefferson had nothing to do with the writing of the Constitution. He wasn't even in the country at the time. But Jefferson had a lot to say about the Constitution. And he said that the original error was in establishing a judiciary independent of the nation and which from the citadel of the law can turn its guns on those they were meant to defend and control and fashion their proceedings to its own will. The judicial branch has a large degree of power. And Jefferson recognized some of those dangers. In fact, Jefferson recommended several changes to the Constitution that he felt would have improved the judiciary. He felt that the judiciary needed to be independent of other branches of the government. You don't want the judicial branch of government to be a very political branch. And as we see with the Supreme Court, those judges are not in the public eye very often. They don't deliver a lot of political speeches and that kind of thing. That's why they're appointed to a lifetime appointment, is so they can maintain that independence. But Jefferson said they needed to not be independent of the will of the people. And often what we see with the Supreme Court, as with other courts, as with state courts as well, is that often these courts are activist courts. And rather than representing the will of the people, the courts kind of lead the will of the people in certain directions, and that really isn't their job. That is the job of the legislature maybe, but the legislature is much more accountable to the people. The check in the Constitution on the judicial power is the ability to impeach judges. But Jefferson recognized that this was nearly impossible. It requires a 2/3 vote, and because of political considerations, that's very, very difficult. In our entire history of our nation, there have been, I believe it's 14 federal judges that have been impeached, and of those, only 6 have actually been removed from office. And so federal judges are pretty safe, even if they commit crimes or misuse their power. Again, only 6 judges have ever been removed from office, federal judges. Jefferson thought that judges should be appointed to limited terms with reappointments resulting from approved conduct. Jefferson thought it would be a good thing if every once in a while that judge would have to be reconfirmed, and probably would be a good thing. He also believed that court decisions should be given seriatim. Now what that means is, today when you read a Supreme Court decision, often there is a majority decision and then a minority decision, and there may also be a few other decisions in any given case. And what happens is that each justice does not write out what their position is on the case that's before them. One of them will write out what their position is, and the others will join themselves to that decision, and they don't really say what their thoughts are, they just kind of say what he said, right? And Jefferson thought it would be a good thing if every judge would have to write out how they reached their decision in a case so that people could look and see how that judge was thinking instead of them just signing on to somebody else's decision. And Jefferson believed that other people would see these problems and that they would fix these things. He thought they would be fixed very quickly, but amendment of the Constitution is not an easy thing. And many of these things have never been fixed with regard to the judiciary. Jefferson had a lot of choice words for the judicial branch, especially later in his life. He didn't have much good to say about them. Here he says the judiciary bodies were supposed to be the most helpless and harmless members of the government. Experience, however, soon showed in what way they were to become the most dangerous. That the insufficiency of the means provided for their removal gave them a freehold and irresponsibility in office, that their decisions passed silent and unheeded by the public at large, that these decisions nevertheless become law by precedent, sapping by little and little the foundations of the Constitution and working its change by construction before anyone has perceived that invisible and helpless worm has been busily employed in consuming its substance. And Jefferson recognized the power that the courts have. Even though they don't have the power to make law, their decisions often are treated as if they are law. And how many times do you hear people refer to this decision or that decision as the law of the land? And the truth is, the courts have no power to make law, but in practice, their decisions become law. And Jefferson says it right, that before people realize what's happened, the Constitution has been eroded, it's been sapped. He often used that term to refer to the judicial branch, calling them sappers. That they would just little by little erode the constitutional foundations. Now, there's an important court case that you need to know about with regard to the power of the Supreme Court. In the very early days of the Supreme Court, up until about the year 1800, the court didn't do a whole lot. I mean, they certainly heard these cases, but they did not, the principle of what's called judicial review had not yet been established. Now, the case that establishes judicial review is the case of Marbury v. Madison. And a lot of times you'll hear people refer to this case without really understanding even what the case was about. Now, what had happened was, I mentioned last time that contentious election of 1800, where it took 35 ballots in the House of Representatives before finally Jefferson was elected as president. John Adams was the previous president. John Adams, after the election was over, but before the new president had come in, John Adams was seeking to secure the place of the Federalist Party in the government. And so he appointed a great number of Federalists to federal positions. And one of the things that they did was they created a bunch of new courts and judicial districts. And then Adams, who was a lame duck president, he had the power to appoint judges to those positions. And Marbury had been appointed by Adams. There's a group of judges that are called the Midnight Judges. And they were appointed by John Adams just before Jefferson came in as the new president. Now, these judges had been appointed, and they had been confirmed, but their commission papers had not been delivered. And they had to have these commission papers in order to take their place in that office. Well, under the new presidency, Madison becomes the Secretary of State, and Madison refuses to deliver the commission papers. That would have been his job as Secretary of State. He refuses to deliver the commission papers, keeping judges like Marbury from taking the positions that they had been appointed to. So Marbury takes this to court. He takes the case against Madison, and he was seeking what's called a writ of mandamus. And this is where a court will order somebody to perform some duty that they're supposed to perform. It's a mandate. Mandamus is that idea of a mandate. And really what the court did in this case was the court said, first of all, they said, yes, Marbury did have a right to his commission papers. Okay? But they said that they as a court did not have the power to mandate that Madison deliver the commission papers. Basically, they said there was no judicial remedy. As long as Madison refused to deliver the papers, there was no way for the court to intervene. And essentially what they did was this was the first time where the court admitted the ability to review laws that had been passed by the legislature. Now, the law in question was the Judicial Act that had created these new offices. And again, the court found that those offices were legitimate. They refused to act to force Madison to deliver the papers, but they reviewed that law. This was the first time where the court was called upon to review a law. Now, the court does not have a veto on the law. Sometimes you'll hear about the court overturning this law or overturning that law. The court does not have a veto power. But what happens is that when the court rules a certain law as being unconstitutional, now that law becomes unenforceable. Because anyone who tries to prosecute somebody under that law, a lower court is going to side with the Supreme Court and they'll just throw the case out, and the law becomes unenforceable. And it was this case that established that idea of judicial review. Now, again, in this case, the court did not overturn any law, but what they did was they claimed the right to be able to review those laws. And so when you hear about the Supreme Court overturning this law, overturning that law, they are exercising that power that isn't really spelled out in the Constitution, but that was established first with this court of Marbury v. Madison of judicial review. And that is, I mean, even though we may not always agree with how the court uses that power, that's an important power. Otherwise, the Constitution could be violated without there being any judicial remedy to the problem. Again, we may not always agree with what the court does in that regard, but somebody has to decide if the Constitution is the supreme law of the land. Somebody has to have the authority to decide whether a federal law falls under the Constitution or not. All right? And so that's the judicial branch. Now, those first 3 articles of the Constitution lay out those 3 branches of government. The following articles give various other descriptions of proper government power, limitations on the states, that kind of thing. And if we go back to our diagram, so now we have the Supreme Court added into the diagram, and Article 4 now is going to deal with some basic things regarding the states. And Article 4, Section 1 is what's called the full faith and credit clause. It says, full faith and credit shall be given in each state to the public acts, records, judicial proceedings of every other state, and the Congress may by general laws prescribe the manner in which such acts, records, and proceedings shall be proved, and the effect thereof. Now, the purpose for this is they did not want somebody, for instance, who had been convicted in one state to simply run to another state to escape justice. Okay? And so each state has to give full faith and credit to the public acts, records, and judicial proceedings of the other states. This is used primarily to enforce judgments. Okay, so if you have a judgment against you in one state, maybe an unpaid debt that's gone to court or whatever, you can't escape it by just going to another state. That other state, their system is going to back up the judgment that was made in a different state. Part of the intent of this is also to prevent what's called forum shopping. Now, this still happens, but sometimes when people want to bring a court case, they're going to look for which state has the laws that best are going to favor them. By the way, Wisconsin, our state, has become a particularly favorable state for forum shopping because with regard to class action lawsuits and this kind of thing, the courts here in Wisconsin have said that you can sue a company with a class action lawsuit, for instance, lead paint. You can sue the paint company and you don't even have to prove that you actually used the product. Okay, if you can show it's a dangerous product here in Wisconsin, you can get a judgment from a company even if you've never used their product. So forum shopping still happens, but part of the intent of this is to limit that. It has effects on things like marriage laws. If you get married in the state of Wisconsin and you move to the state of Illinois, your marriage is still good in the state of Illinois. Now, there has been some question recently about things like homosexual marriage, and some states allow it, some states don't, and currently the way the federal law right now is good in that it says that in those cases, states do not have to recognize marriages in another state. It leaves it up to the states to decide what their policy is going to be. And that's always the best thing. The Constitution doesn't give the federal government authority over marriage, and some people want an amendment to give the federal government that authority, and that'd be a bad thing. All right, it's best to leave those matters with the states. It has effects on child custody and child support. You can't go to a different state to escape child support payments. Protective orders, that same kind of thing. They're valid if you have a protective order in one state. That's valid even if you travel to another state. Okay? Now, Section 2, then, is what's called the Privileges and Immunities Clause. It says, the citizens of each state shall be entitled to the privileges and immunities of citizens in the several states. Okay, now this is somewhat similar to the Full Faith and Credit Clause in Section 1. This is something that applies to basic civil rights. All right, if a state recognizes certain rights of its own citizens, it can't violate those rights if somebody is a visitor, a non-resident. Okay, they have to treat non-residents the same as they treat the state's own citizens. Now, it does not mean that a state is bound to treat their citizens in the same way that other states do. Okay, so if Illinois passes a law, it doesn't mean Wisconsin has to recognize that law in Wisconsin. But what it means is that if a state treats its own citizens in a certain way, it has to treat people from other states in the same way. There's a lot of cases that come up with regard to this because, there are certain areas where states will have different policies for residents and non-residents. University tuition, for instance. State universities, they charge different tuition for state residents than they do for out-of-state students. Hunting licenses. This is a case that has gone to the Supreme Court regarding hunting licenses. If I go to the next slide, there was a case, Baldwin v. Montana Fish and Game Commission, where Montana, like most states, they charge one price for hunting licenses for residents, and then there's an out-of-state price. And the question that came before the Supreme Court was, does the distinction made by Montana between residents and non-residents in establishing access to elk hunting, does it threaten a basic right in a way that offends the Privileges and Immunities Clause? And in that case, the Supreme Court said that no, it doesn't. They use a two-part test. They ask, first of all, does the law discriminate against people from out of state regarding fundamental rights? Now, again, different people are going to disagree about what fundamental rights are. Some people might say hunting is a fundamental right, others might say it's not. But the second question is there a substantial reason for the difference in treatment, and does the law have a substantial relationship to that reason? And with things like tuition and hunting licenses, you could claim that there is a reason for the difference. The reason being that residents pay state taxes, right? And taxes go to some of those things, Department of Natural Resources or to the university system. The non-residents don't pay that taxes, so there's a reason for the difference. Okay, this is how the court has ruled in these issues. Article 4, Section 2 also says that a person charged in any state with treason, felony, or other crime, who shall flee from justice and be found in another state, shall, on demand of the executive authority of the state from which he fled, be delivered up to be removed to the state having jurisdiction of the crime. Now, this is the extradition clause. Okay? And there was an interesting case involving Dennis Banks. Dennis Banks was a part of the American Indian movement. If you're familiar with the events at Wounded Knee, Banks was involved in that. He was charged with inciting a riot in the town of Custer, and he fled to California. Now, he was wanted in North Dakota for some of these charges, for some of the things that he had done, and the governor of California, Jerry Brown, refused to extradite Dennis Banks. He claimed that Banks' life would be in danger in South Dakota. And the Attorney General, South Dakota. The Attorney General there was Bill Janklow. And there was a lot of bad blood between Dennis Banks and Bill Janklow. Janklow had been accused of raping a young girl on the Indian reservation, and in fact the reservation had held a trial and I believe found him guilty. Of course, he just stayed off the reservation then. Janklow just stayed off the reservation so that they wouldn't have any authority over him. Janklow later became the governor, two different times became the governor. But as Attorney General, you know, California wouldn't allow him to be extradited, and what Janklow did to get retribution against California was there were 93 convicted criminals that Janklow made a deal with that he would not send them to prison if they would move to California. And he said since California seems to welcome outlaws, he would just send those people there. And you know, some people would say that Jerry Brown was violating this extradition clause of the Constitution. You know, there's always a case to be made, as Jerry Brown did, that he said that Dennis Banks' life would have been in danger in South Dakota. In fact, Bill Janklow was on record as saying that the only way to deal with Dennis Banks was with a bullet between the eyes. Okay, and you know, certainly he wouldn't have minded seeing Dennis Banks dead. But that's just a case that involves that extradition clause there. Also in Article 4 you have the fugitive slave clause that required that if slaves escaped from a slave state into a free state, they had to be returned. All right, this was something that came up in the Dred Scott decision, for instance, where a slave owner had brought his slave into Wisconsin, which was a free state. Later, I mean, this was used as a political case. The case wasn't brought until much later, and the argument was that by bringing him into a free state that he should no longer be a slave. Dred Scott was kept in slavery under this fugitive slave law. Article 4, Section 3 has to do with new states being admitted into the Union. And from the time the Constitution was ratified, we've gone from 13 states to now 50 states. And it specifies that no state can be formed within the jurisdiction of any other state, except it says without the consent of the legislatures of the states concerned as well as of the Congress. And you know, there is one state in the United States that was formed out of the territory of another state, and that is the state of West Virginia. If you ever want to read an interesting history, read the history of the state of West Virginia. This was, as you might guess, in the Civil War era, and Virginia seceded, and West Virginia was under the control of federal troops. And so there was a vote as far as whether West Virginia was going to secede from Virginia, okay? And that vote was heavily influenced by the fact that many of the polling places had federal troops stationed outside. The Virginia legislators had left Washington. They had come home, and it was just a very messy affair. Really, by right, West Virginia should be a part of Virginia. This was a violation of the Constitution, what took place in the forming of the state of West Virginia. Article 4, Section 4 guarantees to every state in the Union a Republican form of government. Now, the Constitution really doesn't specify what the form of government is for the federal government because it's a federation of these states, but it specifies that every state must have a Republican form of government. Note, not a democracy, but a republic. And the Founding Fathers were not great fans of democracy. John Adams said that democracy never lasts long. It soon wastes, exhausts, and murders itself. There never was a democracy yet that did not commit suicide. And as we've looked at our chart of the government and some of the changes that have taken place, we've seen how we've moved away from a Republican form of government toward a democratic government. And democracy sounds like a great thing, you know, put the power in the hands of the people. In practice, democracy, as John Adams said, it commits suicide. Look, for instance, at the state of California, where they have a very democratic referendum process. And you see many of the financial troubles that the state is in right now, the state of California, has to do with that referendum process. Because if you can get enough people to agree with you that there ought to be some new expensive state program, you can get it on a ballot and you can get it in place. And California is going to have a very hard time making the kind of changes that they need to make in order to get back on strong financial footing because of the democratic system that they have in place. But the Constitution guarantees to every state a Republican form of government. A Republican form of government tends to be a much more complicated system than democracy. Democracy, you have direct elections, you elect the representatives, and that's the main factor in government. Republics tend to have various layers of government competing for authority. There tends to be a lot more conflict between these different powers at different levels, and that's what makes for good government. You see, if in a pure democracy, what always happens is the majority oppresses the minority. The idea in a republic is that everybody has rights, the minority, the majority, and those rights are not to be violated. James Madison said about democracies, democracies have ever been spectacles of turbulence and contention, have ever been found incompatible with personal security or the rights of property, and have in general been as short in their lives as they have been violent in their death. And again, as we consider this chart, this was the original system with the states electing the senators. In most states, the states chose the electors for president. And instead, what we've gone to is today most of the electors are elected directly by the people. Today, the senators are elected directly by the people. The states are left out there with really no representation in the federal government, and it's no wonder we see the federal government taking over everything. Things that once have been the exclusive domain of the states now are taken over by the federal government. Article 5 specifies the means by which the Constitution can be changed. And the Constitution is by no means a perfect document. Now, I believe that it is the greatest founding document of any nation on the earth to date. But it's not a perfect document. And there are, from time to time, there's a need for amendments to the Constitution. Now, there's two ways to go about that. The amendments can be proposed by 2/3 of both houses of Congress, so the legislature, if it's a supermajority of the legislature can propose amendments to the Constitution. Additionally, the second method is if 2/3 of the states call for a constitutional convention, that constitutional convention can propose amendments to the Constitution. Now, that second option is a very dangerous thing. In fact, it's never been used since the Constitution has been ratified. Remember, the Constitution was originally written by a convention, but that system, even though we've amended the Constitution nearly 30 times, this system of a convention has not been used, and there's reasons for that. From time to time, states will start to call for a convention, and sometimes it's called a con for short, a constitutional convention. And the problem is, just like the very first constitutional convention, there's nothing to limit them to the purpose for which the convention was called. Remember, the first convention was called to amend the Articles of Confederation. They came up with a whole new constitution. Now, so a con very well in the political atmosphere of today, if a convention was called, they could propose an entirely new constitution. So it can be a dangerous thing. That's why it's never been used. Now, understand the danger isn't maybe quite as great as some people would make it out. Even if a convention proposed an entirely new constitution, it would still require ratification by either the state legislatures or state ratifying conventions. Okay, so the states have to approve whatever changes are proposed through either of these methods. The states have to ratify any amendments to the Constitution. Now, there's only one thing in the Constitution that cannot be changed, and that is that no state can be deprived of equal suffrage in the Senate. No state can be deprived of their equal vote in the Senate. Now, one could argue that going to the direct election, popular election of senators, denied the states of suffrage in the Senate. The people still, certainly can elect representatives, but the states don't really have a vote in the Senate anymore. And so there's an argument that could be made that the 17th Amendment, which provided for the direct election of senators, is unconstitutional under Article 5. Okay? Article 6 deals with it just gives some additional things regarding the new government. One thing was that the new constitutional government would take responsibility for all of the debts and engagements of the Confederation. So any debts under the Articles would still be paid under the Constitution. Any treaties and those kinds of things that had been made were still going to be honored under the new Constitution. Article 6 specifies an order with regard to laws and constitutions and treaties. And this is the order. It says the Constitution, laws of the United States, and treaties supersede all state constitutions and laws. And that's the proper order. The Constitution is the supreme law of the land. Under that, you have laws passed by the legislature. Now, if a law passed by the federal legislature does not conform to the Constitution, it's not valid. It's not proper law. Next, after laws passed in the legislature, you have treaties. Now, treaties are something that more and more are used to pass laws without going through the proper process. And even unconstitutional laws that can't get passed any other way, they'll put them into a treaty, and that's how they'll get it in place. But treaties are under the laws of the United States and under the Constitution. After that, you have the state constitutions and laws. So that if there's something in a state constitution or law that violates the federal Constitution reigns supreme. Article 6 also specifies that all federal and state legislators, executive, and judicial officers are to be bound by oath or affirmation to support the Constitution. If you wonder why this federal Constitution is so important, every local official, every state official, every federal official, from the president down to the dog catcher, they all take an oath to support the Constitution. Now, they also take oaths to support on the state level their state constitutions, state laws, but they all take an oath to support the Constitution. And I would submit to you that most of those people probably are taking an oath to something that they've never read, and certainly that they don't have any special loyalty to. And the Constitution needs to be an issue, not just in federal elections, but in state and local elections as well. Those people are going to take an oath to this document. They need to know what it says, and they need to have the honor to be bound by it. Article 6 also specifies that there are to be no religious tests for federal office. You can't be required to be a part of a single denomination or something like that. Article 7 talks about the ratification of the Constitution. It says that ratification of the conventions of 9 states shall be sufficient for the establishment of this Constitution between the states, so ratifying the same. Now, you may remember that under the Articles of Confederation, it required unanimous consent by all of the states to make any changes. And this was one of the strongest arguments against ratifying the Constitution, which was that the convention had no authority to propose these changes, and that for it really to be ratified, it would require, since the articles were the existing law, that it would require ratification by all of the states. Here James Madison answered that objection, and he admits, he says, in one particular, it is admitted that the convention have departed from the tenor of their commission. Instead of reporting a plan requiring the confirmation of the legislatures of all the states, they have reported a plan which is to be confirmed by the people and may be carried into effect by 9 states only. The forbearance can only have proceeded from an irresistible conviction of the absurdity of subjecting the fate of 12 states to the perverseness or corruption of a 13th. Now, if you remember some of the things that we've looked at previously, you might be able to guess who the 13th is that he's talking about. It was the state of Rhode Island. Rhode Island was not going to go along with any changes to the Articles of Confederation. And Madison argues that this was a terrible situation. He says, from the example of inflexible opposition given by a majority of 1/60th of the people of America to a measure approved and called for by the voice of 12 states comprising 59/60ths of the people. What he's saying is that if they were to operate strictly under the Articles, that a majority of 1/60th, so a majority of 1/60th would be just a little bit more than 1/120th of the population of the states could hold up any kind of change to the Articles of Confederation. He says that that is an absurdity, that that should be the case. And that was one of the weaknesses of the Articles of Confederation. It was a mistake in the Articles of Confederation that it required unanimous consent of the states. Now, after that brings us to the end of the text of the original Constitution. After the Constitution was written, there became two groups. There was one side that supported the Constitution, that went back to their states, called for ratification. And they were called the Federalists. Now, almost all Americans in that day would have considered themselves Federalists. Alexander Hamilton probably is the one who was the least of being a Federalist of any of these men that we're going to talk about, but he was a part of that Federalist Party. They supported the Constitution. They felt it had the right balance of powers between the federal government and the states. Some notable Federalists, James Madison, George Washington, Alexander Hamilton. Now, their opponents came to be called the Anti-Federalists. Now, these men would have, if you asked them, are you a Federalist? They would have said yes, as far as the meaning of the term Federalist. It's kind of like the meaning of the term Republican isn't necessarily what the Republican Party stands for. Same kind of thing with the term Federalist. And even the name was a little bit of a disadvantage to them because federalism was a very popular thing at the time. So when they came to be called the Anti-Federalists, it was like they were against what was popular. Now, they didn't call themselves that. This is what other people called them. Some notable Anti-Federalists: Patrick Henry, Samuel Adams, George Mason, Richard Henry Lee. Now, these were prominent men, and they went back home. Some of them were in the Constitutional Convention. They went back home and they urged people not to ratify the Constitution. It may seem strange to see that conflict. You know, we think about these men and Patrick Henry, give me liberty or give me death, you know, a revolutionary figure. He was against the Constitution, thought it gave too much power to a central government. Samuel Adams, another one. George Mason was a part of the Constitutional Convention. He refused to sign the original Constitution. George Mason came to be called the father of the Bill of Rights because what he said was that if they were going to really have the proper protections with regard to their rights, they needed some explicit statements in the Constitution that told what people's rights were that could not be violated. And Richard Henry Lee, you may remember, again, he made the motion for independence. He also made the motion calling for the Articles of Confederation to be formed. He was against ratification of the Constitution. Their objections were they thought that it gave too much power to the federal government at the expense of the states. They didn't like the idea that under the Constitution the federal government was not barred from having standing armies in peacetime. They felt that the necessary and proper clause that we looked at last time, which said that Congress could pass laws that were necessary and proper for enforcing those 18 powers given to them in Article 1, Section 8, they thought that was going to be used to abuse federal power. And they thought too much power was given to the executive branch. Now, in many of their arguments, they've proved to be correct. If you look at history, many of the things they feared did not happen in their lifetime, but we see the arguments that they feared being used today. Necessary and proper clause, one of those three clauses that's often used to expand federal power. Now, what the Federalists said in defense was they said that the checks and balances of the Constitution would avoid any one branch having too much power. To the standing army argument, they felt that the 2-year limit on military appropriations, that coupled with the 2-year terms of representatives, that was a limit on standing armies. If they were building up too much of a standing army, people could elect new representatives and do away with it every 2 years. And the Federalists were very clear that the necessary and proper clause was only to be understood in the context of Article 1, Section 8. That did not give expanded powers to Congress, that their powers were limited to those 18 things in Article 1, Section 8, and the necessary and proper clause was just giving them the power to legislate on those issues. Okay? Now, it became clear because of this division that if the Constitution was going to be ratified, they would need very quickly to add a Bill of Rights. And many of the states only ratified the Constitution with the understanding that a Bill of Rights was going to be brought as some of the first amendments to that Constitution. And a Bill of Rights was not a new thing in the history of the world. The Magna Carta was essentially a Bill of Rights. It was a Bill of Rights of the English nobles. The English Bill of Rights, the Virginia Declaration of Rights, these would have been predecessors to the Bill of Rights included in the Constitution. Now, the Federalists opposed a Bill of Rights, and some of their arguments have validity. One of the things they said was that a Bill of Rights is traditionally between a king and his subjects, and they said we're not a monarchy. The Magna Carta, for instance, was a Bill of Rights from the king. They said that the text of the Constitution already protected many rights. Habeas corpus was one of the examples that they gave of a protected right. And we saw last time that the Attorney General, the previous Attorney General, said that it's not a protected right. The Federalists said it was a protected right. And probably their most valid argument was they said, if you take some rights and you spell them out specifically and you say you have a right to freedom of speech and you have a right to freedom of religion and freedom of the press, and you list those specific rights, there's no way for you to list all of the rights that you have as God-given rights. And so they said if you list some, it may give the impression that others can be violated. And that's a valid argument. For instance, common law recognizes a right to travel. Okay? Constitution does not specify that as a federally protected right, but it is we would say a God-given right, the right to travel. But states and the federal government are much more likely to put limitations on your right to travel than they are on your right to freedom of speech, because one is spelled out in the Bill of Rights and the other is not. Okay, and so that's a valid argument. If you list some and not others, it assumes that others can be violated, and that's a principle from contract law. If you don't spell things out in the contract, then there's no obligation to recognize those things, and so that's a valid argument on the Federalist side. The Federalists had several advantages in pressing their case before the American people. For one thing, the term Federalist had become a popular term, as I mentioned earlier. Another big thing on their side was that George Washington supported the Constitution. And George Washington was such a prominent figure that for most people in the country, if George Washington supported something, they supported it. And George Washington was a supporter of the Constitution. He was the president of the Constitutional Convention. Something that did a large part to promote the Federalist position was the publication of the Federalist Papers. These were published as newspaper articles, a long series of newspaper articles, first of all in the state of New York, later in other places. The Federalist Papers were written mostly by Alexander Hamilton and James Madison. I think 5 of the papers were written by John Jay. John Jay became sick and didn't write a lot of the Federalist Papers. They were written under a pseudonym. They were written under the name Publius. They didn't write under their own names, and for that reason, some of the Federalist Papers, we don't really know who wrote them, whether it was Hamilton or Madison. Most of them you can figure out who wrote them, and in my opinion, the best of the Federalist Papers are written by James Madison. But the Federalist Papers did a lot to support the Constitution and the ratification of it. And this is a good publication, a good printing of the Federalist Papers with an index that makes it easy to find various things. And the Federalist Papers is the best commentary on the Constitution available. If you want to understand what the original intent was of the Founding Fathers, you need to read the Federalist Papers. They're also available online. They're in the public domain, and so you can find the Federalist Papers in a lot of places. Sometimes it's hard to find exactly what you're looking for, though, in the Federalist Papers, and that's why it can be good to have something with an index. Ratification took place, it took really until the next year to ratify the Constitution. In the winter of 1787, 1788, you have Delaware, Pennsylvania, New Jersey, Georgia, Connecticut, Massachusetts. Later into the spring and summer, you have some of the very prominent states ratifying the Constitution. North Carolina didn't ratify until fall 1789. Now remember, all of the states didn't have to ratify for it to come into effect, and really the new government begins in 1789. The last state to ratify was, you guessed it, Rhode Island. By 1790, by spring of 1790, it was a foregone conclusion. Rhode Island wasn't going to get out of this. They could argue from the Articles of Confederation all they wanted, but all the other states were going to ratify and had ratified the Constitution. So Rhode Island ratifies it somewhat under duress. They didn't really have a choice in the matter in the spring of 1790. And with that, we're going to take just a short break and come back and talk about the Bill of Rights. In this next session, we're going to talk about the Bill of Rights, and the Bill of Rights is the first 10 amendments to the Constitution. Now, we've already gone through all of the text of the original Constitution, but you see how the Anti-Federalists, they stressed the importance of a Bill of Rights. They felt there were certain rights that were so important that they needed to put specifically that these would be protected. Now, another one of the arguments of the Federalists was they said you didn't need a protection of the freedom of religion, for instance, because the Constitution didn't give Congress authority to legislate on that issue. Okay, I mean, they said, there's nothing in Article 1, Section 8 that says they can legislate on freedom of religion, freedom of speech, any of these things, so you don't need a Bill of Rights. But we can be glad that the Anti-Federalists won the argument and got the Bill of Rights included. In fact, George Mason, who, as I mentioned earlier, was one of the delegates to the Constitutional Convention that did not sign the Constitution and was an opponent of the Constitution, he is called the father of the Bill of Rights. Now, originally there were 12 amendments that were proposed, and of those 12, 10 of them were ratified. Interestingly enough, one of the two that was not ratified was finally ratified in 1992. It had to do with when there's a pay increase in Congress, that it does not come into effect until after an election has taken place, so that if the people want to vote out the legislators because they voted for a pay increase, they can do that. And there was no time limit put on ratification. That was ratified in 1992. Now, generally, today, if amendments are proposed to the Constitution, they put a time limit, usually of 7 years, on ratification, so that you won't have people coming back 200 years later and ratifying an unratified constitutional amendment. But the first 10, these 10 of the 12 were ratified, and they really are a fascinating statement about fundamental rights. And I already answered my trivia question, how many amendments were originally proposed in the Bill of Rights? The answer is 12. The First Amendment is a fairly extensive amendment. There's a lot included in it. And I want you to notice, first of all, that it says, Congress shall make no law. Now, when it comes to the Constitution, every word has meaning, and you have to pay attention to what is said and not read into what is said. When the First Amendment says, Congress shall make no law, if we go back to our diagram, Congress is these people right here. Congress is not the states. Congress is not the people. It's not the Supreme Court. It's not the executive branch. Congress is Congress. Now, many of the things in the First Amendment today are treated as if the states are bound by the same things, and that was not the original intent. Okay, now there is a legal process or doctrine that's referred to that's called incorporation, where the Supreme Court will incorporate parts of the Bill of Rights to the states. And what they've done, what the Supreme Court has done, is they've said that even though the First Amendment says Congress shall make no law, it means that the states shall make no law, the local school board shall make no law, anything related with government at all cannot violate these things. Okay? Now, the first part of the First Amendment says Congress shall make no law respecting an establishment of religion. And it's important to understand what that is. You hear a lot today about the establishment of religion. In fact, just this week, a Wisconsin judge in federal court ruled, for instance, that the National Day of Prayer is unconstitutional because it represents an establishment of religion. Now, what the same judge said was, she said that legislative prayer, where they open the legislature with prayer, she says that's allowable because it's nothing more than what she called ceremonial deism. And so since it doesn't mean anything, you can do it, but if you just, if government encourages people to pray on a certain day, that's an establishment of religion. Okay? Now, I'm no fan of the National Day of Prayer, but that argument really is a pretty flimsy argument. What is the establishment of religion? Establishment is the recognition by a state of a specific church as the state church. Okay? Now, if the government were to say everybody on this day has to pray to this God, that would be an establishment of religion. In fact, even that might not qualify if you weren't recognizing a specific church, but establishment is a pretty specific thing. Understand that the Establishment Clause, it was intended to prohibit having a national church. It was intended to prohibit giving federal money to churches or giving special legal favor or consideration to specific denominations. They were trying to avoid what happened in England with the Church of England, where in some cases you could be imprisoned for preaching if you weren't a part of the Church of England. The Church of England still today receives most of its support from the government there in England. That's what they were trying to avoid. Now, it was not intended to prohibit establishment within the states. Now, we'll talk about that. It was not intended to prohibit religious action by state or local governments. It was not intended to regulate activities of public schools or prohibit Ten Commandments displays or nativity scenes or prayers in the name of Jesus Christ. Christian chaplains in the Army cannot pray in the name of Jesus Christ because that's a sectarian prayer, which they say is unconstitutional. That was not the intent of the Establishment Clause. In fact, the states had established churches, many of them had established churches at the time the Constitution was ratified. They certainly, and at the time that the First Amendment was ratified, they certainly did not understand that by ratifying the First Amendment, they would be disallowing their own state churches. You can see in Connecticut, the established church was the Congregational Church. It wasn't disestablished until 1818. In Georgia, it was the Church of England, not disestablished until 1789. New Hampshire, Congregational, 1790. South Carolina, Church of England, 1790. In Massachusetts, the Congregational Church, it was partially disestablished in 1780. Now, what that meant, that partial disestablishment, was you could decide which church denomination your tax dollars would go to support. You still had to pay the taxes still went to the churches, you just got to decide which church. They completely disestablished in 1833. So the Constitution is ratified 40-some years before some of these states disestablished their state churches. Now again, I don't think states should have state churches, but it's not unconstitutional. What did the First Amendment say? Congress shall make no law. Now if a state legislature makes a law, is that violating the First Amendment? The answer is no. It says Congress shall make no law. And so these things that are grouped together in the First Amendment, the intent, the reason all those are grouped together is because these were intended to be specific limitations on Congress, not on state or local government. When we get into later amendments, it uses different wording. It just says, for instance, the Second Amendment says the right of the people to keep and bear arms shall not be infringed. It doesn't say by who, it just says it shall not be infringed. But the First Amendment is intended to limit Congress and Congress only. And so they can make no law respecting an establishment of religion. Again, forming a national church. They cannot make a law that prohibits the free exercise of religion. Now, probably one of the most notable examples of violation of the First Amendment, that part of the First Amendment, is found in the tax code, the IRS code. And there's a portion of the tax code that's known as the Johnson Amendment because it was put in place by Lyndon Johnson. Lyndon Johnson, there were some prominent church organizations in his state that were opposing him in his election, not his election as president, but his election in the legislature. And he wanted to limit those church organizations from being able to affect his campaign. And so what he did was he got an amendment to the tax code in place that in what's called 501c3, that section of the tax code, it defines what a church is, and it says that you don't qualify as a 501c3 church unless, it says, no substantial part of the activities of which is carrying on propaganda or otherwise attempting to influence legislation, and which does not participate in or intervene in, including the publishing or distributing of statements, any political campaign on behalf of or in opposition to any candidate for public office. Now, this portion of the tax code has never been tried before the Supreme Court. In fact, there's a group right now that's trying to get churches to challenge this by intentionally disobeying it, having a pastor preach a message, endorsing a candidate, record the message, and send it to the IRS in hopes that the IRS will come after that church and they can take this issue to the Supreme Court and get the Supreme Court to determine whether that is a violation of the First Amendment. It certainly, somebody's religion might require that they be involved in political campaigns. I don't know of any religion that does, but let's say yours did. This would say your church can't participate in that. And so likely that is a violation of the First Amendment, and it prohibits the free exercise of religion. Now, one term you often hear with regard to the First Amendment is the term separation of church and state. A much misunderstood term. Now, if you read the First Amendment, you saw those words are not there. Separation of church and state is not in the Constitution. The first place where you see a reference to the separation of church and state is in the writings of Roger Williams. Now, Roger Williams is one of those contrarian founders of Rhode Island who opposed all these established churches in the other states. Rhode Island never had an established church. And Roger Williams, he was a Baptist preacher, by the way. Roger Williams referred to a hedge or wall of separation between the garden of the church and the wilderness of the world. Now, what he's talking about there is not something to protect the government from the church, but he's talking about a wall to protect the church from the world, right? And that's the free exercise clause of the First Amendment is there to protect the church from interference by the government. Now, when people refer to separation of church and state, they are referring to something written by Thomas Jefferson. Now remember, Jefferson did not write any part of the Constitution. Jefferson was not even in the country at the time of the writing of the Constitution. Jefferson can comment certainly on the Constitution, but his views don't necessarily represent the views of the drafters of the Constitution. But Thomas Jefferson, as president, in responding to a letter that he had received from the Danbury Baptist Association, he said, "I contemplate with sovereign reverence that act of the whole American people which declared that their legislature should make no law respecting an establishment of religion or prohibiting the free exercise thereof, thus building a wall of separation between church and state." Now that's what people are quoting when they talk about separation between church and state. Not the Constitution, a letter from Thomas Jefferson. And if you want to see really what Jefferson's view about that separation was, the best thing to do is look at his actions. All right? Now, Jefferson, as president, he refused to issue proclamations of thanksgiving sent to him by Congress. Now, the presidents before him had done that. They would issue these proclamations of thanksgiving, calling for people to give thanksgiving to God. As president, Jefferson felt that was unconstitutional, and he would not issue those proclamations. However, when he was governor of Virginia, and the Virginia legislature would send him proclamations of thanksgiving, he would issue the proclamation. So Jefferson saw a difference between action by the federal government and action by the state government. As the state executive, he would issue those. As the federal executive, he would not. In Jefferson's day as president, there were church services every Sunday at the Capitol. Jefferson faithfully attended. As governor of Virginia, Jefferson created a policy that required students at the University of Virginia to attend religious worship of their choice every morning. Now, they didn't have to attend just, one specific church. They could choose which church they wanted to attend. But Jefferson's policy for the University of Virginia was students were required to attend religious worship every morning. Okay? You see how his standard for federal separation was different than the standard for the state government. As president, he allowed new congregations to hold services in government buildings. As churches were forming there in Washington, D.C., he allowed them to use government buildings to hold services. He, in one case, granted federal land to a United Brethren Society for missionary work. So you see that Jefferson's wall of separation isn't quite what some people make it out to be if you look at what his actions were. Okay? All right, so moving on then to freedom of speech. Congress shall make no law abridging the freedom of speech. Today, often you hear people use the term freedom of expression. And they will apply this freedom of speech to all kinds of things, different pieces of art and things. The National Endowment for the Arts gets in trouble every once in a while because they give federal funding to some obscene art or something like that. If they wanted to say freedom of expression, they could have said that. They said freedom of speech. And they were really talking about political speech. They didn't want people to speak out against the government and then have the law come after them to try and prosecute them for that speech. And so they say Congress cannot pass a law that abridges the freedom of speech. There's a couple things to understand when it comes to the exercise of rights. And when it comes to freedom of speech, a lot of people try and assert that right in a way that isn't really proper. For one thing, no one else can be forced to subsidize the exercise of your rights. You have the right to freedom of speech. That doesn't mean that a radio host can't cut you off when you call into their radio program. It doesn't mean that the television station has to give you a program or give you airtime to air some program that you want to air. Because your right, you have the right, certainly you would have the right to go out and form your own radio station and say what you want, or form your own television station. And so that's not a violation of the First Amendment when somebody with their private property, their private radio station, their private television station doesn't give you a forum to use your freedom of speech. Nobody else has to subsidize the exercise of your rights. If you exercising your right is going to cost somebody else money, then you probably don't have the right to that. They may allow you to do that, but that's not a right. Also, freedom to exercise a right does not give you immunity from the effects of that exercise. You have the freedom of speech, but if you go out and incite a riot that causes property damage and all kinds of other things, you're responsible for the effect of that speech. Okay, so you can't just claim, well, I have freedom of speech, so it doesn't matter what the effect is. The speech isn't the problem in that case, it's the effect of it. Okay, and so you have to understand a couple of those things about exercising rights, and that goes not just with freedom of speech, but other rights as well. There's an issue right now that's been debated in Congress having to do with what's called net neutrality, and it has to do with how the internet operates. And there's a lot of people that have lined up on the side of this net neutrality legislation, and they don't understand what it is at all. Some people think it's about censorship, that it's saying that internet companies cannot censor you and that kind of thing. First of all, it's not even about censorship. It's really about technical issues about how packets of information are delivered over networks. But what the legislation would do is it would say that the person who built the network can't really control how data flows over that network. Now, there's an example where these people who support net neutrality are first of all, they're claiming some rights that really aren't even involved in the legislation, but what they're wanting is somebody else to build a network, build the infrastructure, put all these things in place, and then allow themselves to be able to use it for free as if it's just kind of a public domain thing. And they need to understand that principle. People can't subsidize, or your right does not require somebody else to subsidize that right. Okay? So you got freedom of speech, but understand you're responsible for how you use that liberty. Now, the First Amendment also protects the freedom of the press. And a notable case early on where this was violated was the Sedition Act of 1798. Now, John Adams, again, I've mentioned several times that election of 1800, and there were a lot of rifts that were taking place in the country. The Federalist Party, of which John Adams was a part, was kind of losing some of their political power to the Democratic Republicans. And the Sedition Act of 1798 was signed into law by John Adams. It made it a crime to publish false, scandalous, and malicious writing against the government or its officials. Okay, now, all right, publishing false writing, there might be some case for that, but something might be scandalous and yet be true, right? Or it might be malicious and yet be true, and certainly you would have a right to publish that. But John Adams, really what it did was it made it a crime to criticize the Federalist Party. Okay, that's really what the law did if you look at what it says. And this is also one of the early cases where state nullification came into play. Madison and Jefferson, now Madison, was one of the Federalists who supported the Constitution, but he opposed this Sedition Act of 1798, and Jefferson also supported it. Those two men, in that case, authored the Kentucky and Virginia resolutions. They're also called the Kentucky and Virginia Resolves. Madison wrote the Virginia one, Jefferson wrote the Kentucky one. And what they said was, first of all, they said that the federal government is a compact of the states with only limited powers. That's what we've been talking about. Basically, these resolutions were a defense of the Constitution. They said that the Constitution only gives Congress the power to punish treason, counterfeiting, piracy, and offenses against the law of nations. And that's true. Go look it up in the Constitution, go to Article 1, Section 8, and see what does Congress have the power to punish. And it's those things right there. Now you think about all these federal laws that we have and federal punishments, those are the only things that constitutionally they have the power to punish. And what Madison and Jefferson said was that the states have the right to judge the constitutionality of federal laws and nullify unconstitutional laws. Now, what this is it's really a restatement of an age-old legal doctrine called interposition. And interposition is referring to when you have different levels of power, which you have in any kind of government, that if a higher magistrate, if a higher level of government is abusing their power, that it's the responsibility of the lower magistrate to oppose it in order to protect the people that are in his jurisdiction. In feudal times, this was used by lords when they felt that their vassals were being violated by the king. The lord would oppose the king and he would say, no, that rule of the king is not going to apply in the lands that I control. And so what Madison and Jefferson said was that the states have not just the right, but really the duty to interpose themselves between the federal government and the people when the federal government steps outside of that compact of the Constitution. And what Kentucky and Virginia were saying was that they were not going to allow the federal government to enforce that law within their states. Now again, the states don't have a veto like the president does on laws passed by Congress, but they do have the power to do things like this. And again, good government results when all the different levels of government are opposing one another to exercise the just powers that they have. And when the states stand up and they say, no, we're not going to allow this or that federal law to be enforced in our state, that results in good government. It results in more freedom, more liberty for the people. And that's many of the things that we see in these federal government laws that are being passed today that step outside of the Constitution. It's good to see the states standing up and starting to basically repeat the same kinds of things that were written in the Kentucky and Virginia resolutions. The First Amendment also protects the right of the people peaceably to assemble. That's what we're doing here today. We're assembling peaceably. It doesn't protect your right to assemble non-peaceably. It doesn't respect your right to commit treason against the government and that kind of thing. But you have the right to peaceably assemble and the right to petition the government for a redress of grievances. And that was something that's a right that has not always been recognized. In fact, early on in the House of Representatives, they had certain days that were set aside just for the representatives to read petitions from their constituents. Remember, the House of Representatives was there to represent the people directly, and they would read these petitions, and every petition would be sent to some committee. Now, the committee didn't have to do anything with it, but these petitions would be sent to committee for them to consider as they considered various pieces of legislation. Today it's kind of hard. I mean, you can petition, certainly, the government, but it's hard to get them to pay attention to those petitions. Now, the Second Amendment, it recognizes the right to keep and bear arms. It says, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now, this has been a contentious issue in our day. Some people say that this is a right only of the states or of the militias. Most people, when they read about the militia, they think maybe of their state National Guard. Really, the militia is the able-bodied men organized into companies, regiments, brigades, with officers, required by law to attend military exercises on certain days, but at other times left to pursue their usual occupations. Okay, now the reason people equate this with the National Guard, the National Guard, when you're not called into service, you give, usually it's 2 weekends a month, I think, and then 2 weeks a year. But what the militia was it was all the able-bodied men, and they would have these militia musters where everybody would show up, they would do military exercises. It was basically more for local local defense and that kind of thing. Now, they could be called into federal service, but all the able-bodied men were a part of the militia. Okay? So to say that the Second Amendment only applies to state National Guards really doesn't recognize what the meaning of militia is. By the way, no state today has a constitutional militia. I think just recently I've heard of a couple of states that I believe it was maybe Oklahoma or Kansas that is looking at reestablishing their state militia, and that would be a good thing. Okay? But the Second Amendment is not really about the militia at all. Notice what it says: a well-regulated militia being necessary to the security of a free state. Now that's the reason for this amendment. But what does it say? Who has the right to keep and bear arms? The right of the people to keep and bear arms shall not be infringed. The right to keep and bear arms is not a right of the state. It's not a right of the militia. It is a right of the people. You see? Again, not the states, but the people directly. Notice it doesn't say just Congress shall make no law. It says that right shall not be infringed. And I would submit to you that the reason for the difference in wording between the First Amendment and the rest of these amendments is the First Amendment was intended to limit Congress specifically. The rest of these amendments were intended to limit all levels of government. Now, I mentioned incorporation earlier. One of possibly the only amendment of the Bill of Rights that has not been incorporated by the Supreme Court to the states is the Second Amendment. The Supreme Court has never said that the Second Amendment applies to the states. So they take the First Amendment, which is supposed to limit Congress, and they limit everybody with it, limit the states and local government and school boards and everybody, and then something which is supposed to limit all branches of government, they say, no, that only applies to the federal. Okay, but the amendment just says that right shall not be infringed. It doesn't specify by who it shall not be infringed, which means it shouldn't be infringed by any branch of government, any level of government. The Fourth Amendment protects the right to, sometimes it's called the right to privacy. You have the right to be secure in your persons, houses, papers, and effects against unreasonable searches and seizures. If somebody's going to come and search your home or your personal property, they are to have a warrant. They have to have probable cause to get a warrant. Now, certainly, if there is circumstances, if a police officer sees somebody trying to kill someone, they don't have to go get a warrant before they can arrest them or search them and that kind of thing. But in most cases, where they're investigating a crime after the fact, they're supposed to get a warrant. Now, we see this being eroded. We see many cases where warrants are considered to not be necessary anymore. Now, I want you to notice it doesn't say the right of citizens. It doesn't say, it doesn't limit. It just says the right of the people. And a lot of times people treat these things as if non-citizens don't have rights. But remember that rights don't come from the government. You don't have rights because you're an American citizen. You have rights granted to you by God, right? Man's been endowed by his Creator in the Declaration with unalienable rights. And this just says that the right of the people shall not be violated. A warrant, by the way, cannot just be a general warrant. They can't go on fishing expeditions to see what they turn up. The warrant is supposed to describe the place to be searched and the persons or things to be seized. And so they're supposed to say what they're looking for in the search. The Fifth Amendment is, you've heard of pleading the Fifth. The Fifth Amendment protects your right against self-incrimination. There's actually several judicial things in the Fifth Amendment. One of the things is it talks about a grand jury. In order to be held for a capital crime, it says, or otherwise infamous crime, there has to be a presentment or indictment of a grand jury. Now, an indictment is when a prosecutor goes to the grand jury and says, here's the evidence, we want you to indict this person so that we can arrest them and hold them for trial. A presentment is when a grand jury, without any request for an indictment, when a grand jury just goes and investigates a crime on its own. A lot of people don't realize that grand juries have that power. If they know of a crime that's been committed, or somebody presents evidence to them about a crime that's been committed in their jurisdiction, they can go investigate it on their own. And that's an important check, because sometimes you might have a prosecutor who wants to protect somebody and doesn't ask for an indictment. The grand jury can go and investigate it themselves and issue a presentment. And so there are some exceptions there for military offenses. But otherwise you got to have a grand jury indictment or presentment. You're also protected from double jeopardy. And what this means is that if you're found not guilty of a crime, you can't be tried again for the same crime. And this is to avoid where the government will decide they're going to get somebody no matter what they have to do, and so they can try somebody over and over and over again for infinity, keeping them in prison and that kind of thing. And even if the person is found not guilty, they might try to come after them again. But here you're protected from what's called double jeopardy. And it says you can't be compelled in a criminal case to be a witness against yourself. That's pleading the fifth. You can't be deprived of life, liberty, or property without due process of law. And the end of the Fifth Amendment says that private property cannot be taken for public use without just compensation. Now, this is talking about eminent domain, where property is taken for public use. And you see, it can be done. It has to be taken for public use, and it has to be done with just compensation. Now, a fairly recent example of a prominent case, eminent domain case, was the case of Kealiher versus the City of New London. And in that case, there was a private developer that wanted to take 90 acres of land. He wanted to put in a residential development. They were going to put in a hotel and conference center, research and development space. Part of it would be a new state park. And Pfizer Pharmaceutical Company wanted to put in a $350 million research center. Now, these developers, when they come to a community and they want to do this, they always make these grand promises about what the results will be. This developer said that by taking this 90 acres and letting them develop it, that it would create 3,169 jobs, and that it would generate $1.2 million per year in tax revenues. Now, if you're sitting on a local board, or you're a local supervisor or something like that, that sounds pretty attractive, right? Over 3,000 new jobs, over $1 million every year in additional tax revenue from that property, okay? And so they took the land under eminent domain. Now, there were a few people who challenged the taking, and one was Ms. Kealiher. Ms. Kealiher lived in a historic house. It was, I forget how old, over 100 years old. It was kind of a landmark there. She did not want her property to be taken and took the case all the way to the Supreme Court. And the Supreme Court ruled that the city could take that property. Now, one of the things they did was they expanded what the meaning of public use was. Public use would be sometimes if you're going to build a road from here to there, there's sometimes just because of the geography of the land, you have to go through a certain property. And if that road has important uses for various things, what it does is that property owner could hold out and say, I want $1 million an acre for my property, and hold everybody else hostage so that road couldn't be built. And so there are some cases where that land can be taken for public use, to build a road, to do various other things. Okay? In the community where I live, there's two towns. There's Adams and Friendship that are very close to one another. And originally the railroad was going to go through Friendship, but the people in Friendship wanted too much for their land, and so they went a few miles south into Adams, and that was a case where they didn't use eminent domain. The result was that Friendship was hurt by it, and Adams benefited, and Adams grew much faster than Friendship did because those people were greedy, you see. But here this case, they want to put in this development. Now this development is not for public use, right? They're going to put in houses that the developer is going to sell and make money off of. They're going to put in rental units that the developer is going to make money off of. They're going to put in a hotel and convention center that the developer is going to make money off of. This isn't public use. Maybe you could say the state park would be public use, but much of it is private use. What the Supreme Court did, though, was they expanded the meaning of the term public use, and they said that it could include anything that was for public purpose, including that if that local community is going to get higher tax revenues off that property, they say that's a public purpose. And so that qualifies now, according to the Supreme Court, as public use, which basically means that a local community can take any property they want for any reason whatsoever. All right. Now they do have to compensate the person, but just compensation is a thing that's up for debate and argument. What you consider to be just compensation, that property may be worth a lot more to you than what they consider it to be worth, but the Supreme Court ruled that taking was okay. In response to that, if there's anything good that came out of the decision, it's that 42 out of 50 states realized this was a bad situation. And 42 states have changed their eminent domain laws to forbid the taking of private property for the benefit of private development. All right, so even though the Supreme Court said it was okay under federal law, 42 states have said, no, it's not going to be okay in our state under state law. By the way, if you're wondering what happened with that property, this is what the lot that Susan Kelo's house sat on, that's what it looks like today. The developer didn't come through. I mean, you can see they put in a few things there, but all of these grand promises that were made never panned out. And that city, probably gained some tax revenue and maybe gained a few jobs, but this that used to be a residential neighborhood, you see now, it's just empty land, serving no purpose whatsoever. And that's the result in many of these schemes where these developers will come in. And I would bet that picture was taken before a lot of the recent things that have happened in the economy. And I would bet much of the rental space and business space that was put in is probably sitting vacant today as well. The Sixth Amendment guarantees a right to a speedy and public trial. It also guarantees a right to trial by jury, as well as a lot of other things. You have the right to be informed of the accusation against you. That just seems obvious to us, but understand there were times in England, for instance, many of these things were to address the abuses that had taken place in England. There were times in England where you'd be put on trial and never told what the accusation was. Now, how do you defend yourself if you don't know what you're accused of? You have the right to be confronted with the witnesses against you. So you have the right to know who it is that's testifying against you. You have the right to what it calls compulsory process for obtaining witnesses in his favor. If you know that somebody saw what you're being accused of and they saw that you didn't do it, they may not want to come forward. Maybe they're afraid that somebody else will come after them, or maybe they don't like you and they don't want to help you out. You have the right to compulsory process where they can be subpoenaed and they have to come into court and testify. And you have the right to assistance of counsel. The power of a jury, you could almost treat the jury as maybe not a separate branch of the government, but it's a check of the people on the government. The history of the jury is an interesting thing. Here's the case of William Penn. William Penn, who was the founder of the state of Pennsylvania. In England, William Penn was arrested for preaching Quakerism. The state church was the Church of England, and he was preaching Quakerism contrary to the law, and he was arrested. He was not allowed to see what the charges were against him, all right? And the judge directed the jury to come to a verdict without hearing his defense. Not only did he not know what the charges were against him, normally the prosecution, they make their case, and then the defense, you get to call your witnesses and show why the prosecution is wrong. Well, they get to the end of the prosecution part, the prosecution says why he's guilty, and the judge tells the jury, okay, come back with a verdict. You don't get to hear what the defense is. Now, the jury in this case, they apparently saw what was going on, and they came back with a verdict of not guilty. Now, it's obvious what the judge wanted to happen, but the jury said, no, we're not going to go along with it, and they came back with the verdict of not guilty. That's a very powerful right that a jury has, and the jury has the right, by the way, not just to judge the fact of the case, but to judge the law as well. A jury can say not guilty for any reason. All right, even if you think the person did what they're accused of doing, but you think the law is wrong, the jury can say not guilty. Okay, it's a check of the people on the government. In this case, the jury came back with a verdict of not guilty. Now, the result was, first of all, the judge invited the jury to reconsider and select a new foreman. The jury refused to do that. Next, the jury was sent to prison without food or toilet facilities for 4 days. Okay? And the jury was fined a year's wages each because they would not rule the way the judge wanted them to rule. The jury fought their case from prison, and they won the right for English juries to be free from the control of judges. Now, today, very often, judges do a similar thing, but in a much softer way. They don't put juries in prison and that kind of thing, but they do give instructions to the jury that are often intended to lead the jury in a certain direction. Judges, never do they inform the jury that the jury can judge the law as well as the fact. They'll tell the jury that their only job is to determine whether the person did what they're accused of, and there have been a few cases in recent years where courts have gone after jurors for their decisions on juries. Historically, jurors, since that time, jurors, there can't be charges against you because of how you vote in a jury room. But there was a case a few years ago where there was a woman who was either a former nun or was currently a nun at the time. She was on a jury, and she felt that this young man that was in court was being railroaded, that she felt he had done, it was drug charges. That's the vast majority of these cases that come into these courts now are drug charges. And she was the holdout on the jury. She knew he had done it, but she didn't feel that what was being proposed, that the sentence he was going to be subject to was fair, and she was the holdout. It resulted in a hung jury. And the judge tried to come after her for perjury. He said that when she took the oath as a juror, that she was violating that oath by not saying that he was guilty. And I don't know whatever happened with that case, but just the fact that a court would try and do that, that's the kind of stuff they were doing back here, right? We're back to before the Bill of Rights, before the Constitution, before United States independence. We're back in English colonial times where people had very few rights, and that's the kind of thing that courts are doing today. John Adams said of juries, he says, it is not only his right, but his duty to find the verdict according to his own best understanding, judgment, and conscience, though in direct opposition to the direction of the court. It's important that every American know what their right is as a juror. All right? And when you know what your power is as a juror, when you realize that one juror has more power than the judge, the prosecutor, the entire executive and legislative branch, and judicial branch all put together, you have more power in that one case than all of them do, jury duty becomes something not that you try and get out of, but it becomes a privilege that you get to sit in that place and exercise that duty and exercise that great power that an individual juror has. Moving on to the Eighth Amendment, the Eighth Amendment specifies that excessive bail shall not be required, that excessive fines cannot be imposed, and that cruel and unusual punishments cannot be inflicted. Now, the only problem with the Eighth Amendment is that all of those terms are pretty subjective. Who determines what's excessive? Who determines what's cruel and unusual? Some people say that the death penalty, for instance, is cruel and unusual. Now, certainly in that day, the death penalty would not have been considered cruel and unusual. Cruel and unusual were the kind of things that they had done in Europe. One of the sentences that was used for a lot of times even for political crimes, but a lot of times for violent crimes and things in Europe, if you really got the government mad at you, they would sentence you to be broken on the wheel. Have you ever heard that term? To be broken on the wheel was they would take a wagon wheel, and a wagon wheel has spokes, right? And they would take a person's arms and break the arm in so many places that they could thread it through those spokes around that wheel, both arms. That's what it was to be broken on the wheel. I talk about a cruel and unusual punishment. So they would put the arm through the one spoke and beat it with a club until you can bend that arm back and get it around the spokes and thread those arms through the spokes. That's the kind of thing they were avoiding, the Iron Maiden and these kinds of punishments. Now, the Ninth and Tenth Amendments, and we're coming close to the end now of the Bill of Rights. The Ninth and Tenth Amendments are very important for understanding the limitations on the government. Now remember, the Federalists said over and over again, they said you don't even need a Bill of Rights because if the rest of the Constitution has not authorized the government to do certain things, then they can't do it. They said you don't need a First Amendment because the federal government has no power to violate your freedom of religion. It has no power to violate your freedom of speech. The Ninth and Tenth Amendments are there to make sure that everybody understands that principle. The Ninth Amendment says, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Remember what the Federalists said? They said if you list some and not others, people are going to assume they can violate the others. This says just because we listed some and not others, that doesn't mean that the people have given up any of their rights. You have every single right, whether the Constitution mentions it or not. All right? And your rights, when people think about their fundamental rights, they think about constitutional rights. You have many more rights than that. Okay? So the Ninth Amendment asserts that you retain all of your rights even if they're not specifically mentioned in the Constitution. So the Ninth Amendment is about the people. The Tenth Amendment is primarily about the states. It also mentions the people. It says the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. Okay? Now, understand that the Constitution is not an ideological document. It's not a liberal document or a conservative document or a libertarian document. What it is it's a very practical thing that just says, here's the power you have. It doesn't say how that power should or shouldn't be used. It says, here's the power the federal government has. Okay? And what this amendment says is it says that the federal government can only do the things that the Constitution says it can do. And it says that if something is not delegated to the federal government and it's not prohibited to the states reserve those powers to do it, and the people reserve their powers to do those same kinds of things. So there are many things that would be unconstitutional on the federal level. Healthcare, for instance, it's unconstitutional on the federal level. It's not unconstitutional on the state level. Now, on the state level really is where you should have a lot more of these ideological battles, right? Healthcare is wrong, government health care is wrong on any level, but it's unconstitutional on the federal level, all right? So the states really retain the majority of power under the Constitution. Now that's not recognized today. The 9th and 10th Amendments are largely ignored, but more and more states are at least beginning to realize the power that they have under these amendments. Many states are passing 10th Amendment resolutions, which really don't carry a lot of power, but they at least show people are waking up to the issue. And that's a good thing. When the states are very aggressive in defending the power that they have, it limits the federal government and it makes the people in that state more free. And that's a good thing. And so that brings us to the end of the Bill of Rights and the end of our class for today. Next time we will look at some more of the later amendments. We aren't going to have time to look at every single one, but we'll look at some more of the later amendments to the Constitution. And also then in the second half next time, we'll look at some important activities for getting things back to constitutional government. We've seen a lot of the problems, we've seen a lot of the violations, a lot of violations that even in the very early days of the United States were taking place. And we'll look at some things that we can do to move things back toward constitutional government. And that's where we'll close for today. Are there any questions?
I had one about the militia. Whatever happened to it? The constitutional militia, not the...
I think it sort of gradually turned into the National Guard. We had a long period of time where we didn't have any threat of domestic hostilities, and it just the same sort of thing happened, I'm sure, to what happened with the militias in Europe. A lot of these European countries, the cities and towns would have militias, and it turned into more of a symbolic type thing than any real defense power. And probably a similar thing happened here, and I'm sure eventually, I haven't studied out the whole history of it, but I'm sure eventually it just kind of became the National Guard and that kind of thing. But the National Guard really is just the name, National Guard. It's a part of it's a part of the national military, and granted, they've been used a lot for local things, disaster relief and that kind of thing, but more and more, it's hard in a lot of places to do disaster relief because so much of the National Guard is mobilized and is overseas somewhere. And it's really become, there was a time where you could join the National Guard and most likely you were never going to be mobilized, never go overseas. Now you join the National Guard and it's really just a matter of time before you're going to some foreign country.
I guess, I never looked into it personally myself, but, it'd be interesting to know if Wisconsin maybe had some old laws on the books that dealt with their militia, for instance, and how the state went about regulating that.
Right. Because the Constitution really specifies that the states have to have a militia.
Right.
See? And it would be an interesting thing to go back and look into that history.